Alex here with part 113 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. This is the beginning of the end for my ex. This is the first domino in what you will see becomes a large, years-long chain reaction that leads to the deprivation of her physical custody, the deprivation of her legal custody, and ultimately the termination of her parental rights. The ways in which this case does that varies, and in fact varies pretty wildly, but at each step of the process, I'll do the best that I can to connect the impact that this decision from the Supreme Court has, not only on my case, but on the entire state of Nevada. This is a published decision, which means that it will control going forward, not just for me, but for mothers and fathers throughout the state, for all of them. So my mindset at this time, interestingly enough, when I saw the title, I was dismayed. I was really upset because I saw Petition denied. But then I read it and I realized I actually won the case. And I will explain, I guess I should explain now more than actually when we go through the document. So the Supreme Court is an appellate court, and appellate courts are not allowed to conduct fact-finding. I don't know if I want to use the word allowed. They don't want to do it because they don't feel it's appropriate. The appellate courts are very distant from the actual controversy, and they are not courts that take testimony and consider evidence. More importantly, they are not courts that weigh evidence. And so for those reasons, they will not make a ruling in a situation like this if their ruling itself creates a procedure that requires fact-finding, and that's what they did. I'm very appreciative of what the Supreme Court did because they didn't have to do it. They could have just denied the petition and stated that we are not a fact-finding court, you lose, go away. They could have done like a 1 or 2 page order, but they didn't do that. They published an opinion and they created a procedure that a parent can use to challenge the confidential address program. And they stated that because one of the steps in that procedure requires fact-finding, that at that time, they couldn't give me the relief that I was requesting. But they specifically state in one of the footnotes that I am perfectly allowed to take that decision that they just published, take that procedure, and file another writ petition in the lower court, which can conduct fact-finding. And I went ahead and did all of those things, and that's where I actually get my ex's fictitious address canceled. But I needed this decision from the Supreme Court because if I didn't have it, the lower courts would not have listened to me. So this decision from the Supreme Court of Nevada, even though on its face says petition denied, still controls the procedure. It creates a gateway where none existed before for parents like me to go through to get the relief that we need to get. And I'm going to go through the technical details as to how this gateway works when I actually go through the opinion that was authored by Justice Michael Cherry. But I did want to let my viewers know so that they weren't confused that this particular opinion, even though it says petition denied, it is the beginning of the end for my ex. I do follow the procedure that the Supreme Court sets forth in the opinion, and I do ultimately get my ex's fictitious address canceled once I file it in the lower court, and that lower court conducts its fact-finding in my favor. So I suppose at this point in time, we should go ahead and take a look at what the Supreme Court has filed. Here we have Nevada Advanced Opinion number 28 of the year 2013, which happens to be volume 129 of the Nevada Reporter. This is, as I mentioned, a published decision, which means other parents who have nothing to do with my case can cite this case in their cases and actually control the outcome of their cases. So what I did here was not just for myself, but for every mother and father in the state of Nevada. If you are in Nevada, in fact, if you are in another state and you would like to use this opinion, you can, but unfortunately in your state, it is only considered persuasive authority, whereas in my state, it is considered mandatory authority. The difference between the two is that a judge in Nevada who does not follow the opinion in this particular piece of mandatory authority will have their decision overturned on appeal if a litigant actually takes them to the appellate courts and states, hey, they didn't follow Falconi, the Secretary of State. So let's go ahead and go into some of the details here. You can see here that this decision was before a panel, and a panel in Nevada is a decision, or it's reviewed by 3 justices. That's how panels work here. Different panels in different states may work in different ways, but in Nevada, a panel is 3 justices. They have some decisions that are considered what they call en banc, which is Latin for full bench, and those are the decisions, at least in Nevada, that are reviewed by 7 justices, and that is the full bench of the Supreme Court of Nevada. This particular decision was not reviewed en banc, it was only reviewed by panel, so we only have 3 judges involved in the review of this decision. This particular decision was authored by Justice Cherry. That's what it states here when it says by the court Cherry. Some decisions are per curiam, and those are not authored by any particular justice. They're sort of coordinated between the 3 of them, and they all kind of have a hand in how that decision came to be. And so those will be per curiam decisions. I'm not sure what the Latin is for that, but anyway, let's go ahead and get into the opinion. First of all, you could see up here that it was denied, but as I mentioned earlier, that is because the procedure set forth requires fact-finding. It's not because they disagree with me. It's not because they think I'm wrong. It's just because they can't actually conduct the fact-finding themselves, so they have to deny it because another judge, a lower court judge, is ultimately going to have to pick up the case, and of course have to file it in the lower courts to get their attention. And we're going to go through all that when we actually proceed through the My Docket series. You will see me file this in the lower court, and you will see me cite this decision to control that lower court and to force them through the procedure that the Supreme Court has set forth. But for now, let's just talk about this opinion in and of itself. First, we have a standard introductory paragraph. The Supreme Court of Nevada indicates or summarizes that myself and my ex share joint legal and physical custody of our child. They point out that my ex obtained, based on evidence of domestic violence, and we're going to talk about this in a second, a fictitious address from the Secretary of State, who cannot disclose my ex's true address without a court order. And the question that they are going to decide is whether I can seek the disclosure of my ex's home address, and they conclude that as a co-parent, I can seek the disclosure of my ex's address in the district court by extraordinary writ. And in determining whether to grant the writ, the court has to consider whether my ex can establish that she is that I am a perpetrator of DV. And by the way, guys, I use these initials because sometimes YouTube will yellow flag the video because they consider DV to be a controversial topic, and it's annoying. And I explained this, I can't remember in which video now, but I think it's one of the My Docket series videos, one of the earlier ones. So if you've been watching in order, you'll know what I'm talking about. I'm trying to get it so that these videos are distributed to as many people as possible. If I let them yellow flag a video, it's still up, but not as many people will see it. So I'm going to keep using that abbreviation as I go through the video. Anyway, if my ex is able to establish that I am a perpetrator of DV, then the burden would shift to me to show that despite this evidence that I am still, or that it is still in the best interest of our son for disclosure to occur. And as this is not the proper court to consider the petition because of the fact finding, which we're going to talk about later, they're going to deny it at this point in time. 2 things that you guys are going to notice. Number 1 is, hold on a second, why did the Supreme Court say that my ex showed evidence of DV, only to 3 or 4 sentences later say that she still has to establish that I am somehow a perpetrator? Where's the disconnect there? The disconnect here is the definition of evidence. The definition of evidence is not what we think it is. As ordinary people, we think that evidence is a photograph or a videotape or some kind of proof, some kind of hard proof. The definition of evidence in the court system varies. First of all, testimony of a witness is considered evidence. Ordinary people don't consider that to be evidence. Ordinary people consider that to be gum flapping. He said, she said. Who knows if it's true or not? Well, in the court system, somebody saying something on the stand as a witness counts as evidence. As weird as that is to us, that's the way it works in the legal system. But then there are other situations like this situation where sometimes evidence is defined by statute. And that's where the problem is in this case. In fact, I actually challenge this language and I file a motion later on. We're going to go over that more in detail when we actually get to that point in my docket series. But in that motion, I state, hey, you guys are confusing. You're saying that there's evidence of DV here. And then later on, you're saying that my ex still has to show that I have, perpetrated DV. So this is confusing. I didn't find out until much later that the courts don't concern themselves with how confused us ordinary folk are when we review these opinions. The courts follow their own standards, they communicate in their own language, and if we don't understand it, then too bad, that's not their problem. That's the approach that they take. They don't write these opinions for us to understand them. They write these opinions for judges and attorneys to understand them. So now I'm going to go ahead and explain what I meant by that earlier statement. Evidence sometimes is defined by statute, and that's the whole crux of this entire opinion. As we go through the opinion, I'm going to elaborate more on what I'm talking about. But in Nevada, in the context of getting a confidential address or a fictitious address from the confidential address program, there is a specific statute that defines evidence, and it contains a list of documents. And in that list of documents is an order for protection. And that's where this whole thing ended up becoming a huge issue, because to get an order of protection, you don't actually have to show that you have been a true victim of DV. You only have to show that you might possibly one day in the future maybe become a victim of DV. So if you go to one of these hearings and get a protective order, not because you've shown that you are actually a victim, but because you have shown the court that you might possibly one day become a victim, now you have a piece of paper that, according to the confidential address program and according to a statute, counts as evidence. So that's why the Supreme Court is saying here that my ex has evidence of DV, but in that same paragraph, they state later that she still has to show that she is actually a victim, that I have actually perpetrated DV upon her. That's why these cases can get so hairy, because of these complexities. And at that point in time, hopefully you guys understand what I'm saying. Hopefully you understand what the Supreme Court is saying. Hopefully you understand that sometimes evidence, according to what we think is evidence, is not evidence according to what the court thinks is evidence. And in this particular situation, evidence is evidence because the legislature said so, not because it actually fits the dictionary definition or our understanding of it. Because the protective order is listed as one of the pieces of paper that counts as evidence, in that context only, that is before the court now as not sufficient to warrant concealing the address of my child from me. And that is why, despite her having that piece of paper, this Supreme Court is still forcing her to, at a later date, show at a later proceeding that she's actually and truly a victim. This is what my ex fails to do, and this is why the confidential address that she has is canceled. Let's go ahead and go into the actual opinion now. Factual background. So this is probably another summary paragraph. I am the petitioner. My ex is the real party in interest. We lived together. We had troubles that led to the end of the relationship. There were some occasions where police were called. There are police reports that are down in the lower courts that were considered. And by the way, guys, if you've been watching the My Docket series, you're going to know all these details, because these are all of the things that the Supreme Court is discussing. If you haven't missed any of the previous videos in the My Docket series, nothing here is going to be a shock or a surprise to you, because you've already gone through it by going through the series. Next paragraph we have, following the events mentioned, we separated. I instituted child custody proceedings in the lower court. A month later, and 5 months after the aforementioned fight involving the police, my ex obtained a temporary restraining order from a hearing master, which prohibited me from having any contact with my ex or our child, and gave my ex temporary custody of our child. This is basically parts 1 through 5 of the My Docket series. The temporary restraining order was issued in a form stating that the court had found that, quote, an act of DV had occurred and or that I represented a credible threat to the physical safety of my ex, unquote. And this is something that I talked about extensively in those earlier videos. It's this and or here that is the piece that is what it was able to get this case to go forward, because now it's not so clear to the Supreme Court. Now they're like, hold on a second. Was it the first part or the second part? Because the first part would show that I'm actually a perpetrator, but the second part would just show that my ex claimed that there might be something that might occur into the future. This is one of the reasons, guys, why these decisions are so hard to appeal. A lot of people get upset when their ex gets one of these orders because they feel like, hey, I haven't done anything wrong. And I just tell them, you know what? Under the law, you don't have to have done anything wrong. They can just say you might maybe do something wrong in the future. What they call future crime may occur. And so anyway, let's go ahead and proceed. At a subsequent hearing regarding the possible extension of the order, my ex testified that at different times, a number of things have occurred, and that she asserted that I had, quote, threatened her during a phone conversation. Of course, I controverted the testimony. I denied it. And even though that there were admissions that hands were placed upon one another, that these were just when I was blocked from leaving. So my admission here is not sufficient to constitute DV. At the conclusion of the hearing, the district court extended the restraining order for 2.5 months. I thought it was 3 months. Okay. Anyway, my ex apparently did not seek any further extensions. And she didn't. So the Supreme Court here isn't certain, but no, she didn't seek any further extensions. 3 months after the expiration, the district court awarded joint legal and joint physical custody of our child to both of us. In doing so, the court did not discuss the temporary restraining order at all and did not make any findings regarding DV. And this just, the Supreme Court isn't 100% certain as to why this didn't happen, but if you guys have been watching my series, you'll know it's because it's nonsense. It didn't happen. I can tell you that given the aggressive nature of my ex's approach to trying to get primary physical custody, that if it had happened, and that if there had been any kind of evidence or any grain or kernel of truth to any of these allegations, she would have definitely brought them up. She would have definitely litigated them, and it would have definitely gone to court. The reason that my ex dropped the DV is because she knew she had no way to prove it because it didn't happen. We're gonna go ahead and continue on. 5 months after the issuance of the order, my ex applied for the confidential or for the fictitious address. And that it's not clear from the record to the Supreme Court what prompted her to do this in her application. She stated that she was a victim of DV, and to support her application, she submitted that old restraining order that she had obtained a year earlier, the expired order. So this is what I was talking about throughout the series, where my ex's attorney basically exploited a loophole in the process to get what she wanted. She didn't really feel that she was actually a victim or that she was in any danger, but there was a particular conclusion that she wanted to reach. And so to do that, she had to exploit a number of weaknesses in the legal system. And this is typically the approach that an attorney will take, especially an attorney who they share the mindset of their client, which is to win at all costs. If you want to learn more about what I'm talking about, please watch the video, Win at All Costs. And you could also take a look at the video, I think I discussed this, Conclusion Before the Facts, where you're dealing with a litigant and an attorney who isn't concerned so much about what's actually happening, and they're just focusing intensely on what it is that they want to get in the end. And so they sort of twist the facts of a case into that particular, to fit that narrative, because they are focused very intensely on getting that particular outcome at the end. Based upon my ex's application and submission, the Secretary of State issued a fictitious address. Initially, I tried to challenge the issuance through a petition for judicial review, which was not the proper approach. On appeal from that order, this court affirmed the denial, but only on the ground that the district court lacked jurisdiction. If you've been watching this series, you'll know what I'm talking about. We already went through these filings. I then filed in this court an original petition for writ of Mandamus, seeking an order directing the government to remove my ex from the fictitious address program. Going into the next paragraph, in my petition, I argued primarily that the Secretary of State should have considered whether the temporary restraining order submitted by my ex was specific evidence that she had been a victim of DV. And I further contend that the Secretary should have concluded that the temporary restraining order was not sufficient for this purpose. So basically what I'm trying to say is that the Secretary of State should take on the role of a judge, and that the Secretary of State should determine whether or not my ex is an actual victim. This is an argument that fails, but it doesn't matter because my backup argument succeeds. My backup argument was that I have a fundamental constitutional right, and since the Secretary of State cannot act as a judge, then I have a right to get this issue in front of a real judge, to have that particular judge determine whether or not DV has actually occurred. So my backup argument will prevail here. Discussion. Extraordinary writ relief is within the court's discretion. What this means is they don't have to consider your petition. They can exercise their discretion to consider a writ petition if they feel like it. They don't really, I mean, there are situations, in fact, more than half of these petitions are just declined. They're not saying that you're wrong. They're just saying, it's not important enough. We don't have time for this. We're too busy. So go away. They're not saying that anything that you've brought to their attention is particularly incorrect. They're just saying that they're not going to even take a look at it. They're just going to decline review, send you off, and unfortunately, there's many times nothing you can do. Sometimes you can get review in the form of an appeal at a later date, but sometimes you just can't get review, which is really sad, but that's what happens in the legal system when it comes to writ petitions. They are entertained at the discretion of the court. They're saying here that I present important legal issues regarding the fictitious address statutes and a co-parent's ability to seek disclosure of the other parent's address. And the Supreme Court is conceding that these issues that I bring to their attention need clarification. They're also conceding that I do not have an adequate remedy at law. Since I have no adequate remedy at law and they consider the issue important, that they have decided that consideration of my writ petition is appropriate. That's huge, guys. To even get your writ petition considered is huge in this state, and probably in any state, because I think, as far as I know, all 50 states entertain writ petitions only at their discretion. You don't get what they call mandatory review like you get in Nevada when you file a direct appeal. When you file an appeal in Nevada, it will get reviewed. It is mandatory that it gets reviewed. Whether you win or lose, that's another question, but it will at least get reviewed. When you file a writ petition in Nevada, you might not even get your writ petition considered. In fact, if you want to learn more about that, please watch my video, Writ Petitions. Now let's take a look here. The overview of the fictitious address program. So the first thing that the Supreme Court wants to do is sort of put together a definition as to what the fictitious program even is. And they're going to take advantage of my writ petition to go ahead and do that and publish it. So the fictitious address program was enacted in 1997 to help DV victims establish and maintain confidential home addresses. To accomplish the goal, the fictitious address program provides that an adult person or somebody acting on behalf of a child, let's see here. Whoa, hold on a second. I'm losing my train of thought here. It was enacted so it's to accomplish the goal. The program provides that an adult person or guardian acting on behalf of an incompetent person has a fictitious address designated by the Secretary of State. It's kind of unclear what they're stating here, but maybe what they're stating is that a person has a program available to them to get that confidential address. It seems like that's what they're talking about. In order to receive a fictitious address, the individual has to submit to the Secretary of State an application containing specific evidence showing that the adult, child, or incompetent person has been a victim of DV. This is what took me to the Supreme Court, guys. This specific law, subsection 2A, which states you have to show specific evidence that you are a victim. This is huge. If you don't have this specific evidence, you shouldn't get this confidential address or this fictitious address. But the problem is that the legislature enacted another statute, and that is subsection 4. This is the problem. This is where they messed up, and they inadvertently, in my opinion, I hope they didn't do this on purpose, the legislature inadvertently, hopefully, created another subsection to that statute, which contains a list as to what evidence is. And here's the problem, because that list contains the actual mention of the temporary restraining order, which you can obtain without showing any evidence at all. This is where these two statutes make no sense. They're contradictory. They clash with each other. And the Supreme Court is going to step in here to clarify what we can do as parents going forward, given the legislature's doublespeak in this particular area of law. So we're going to go ahead and move on. The Secretary of State can cancel a fictitious address at any time if the participant changes his or her confidential address without properly notifying the Secretary. And after 4 years, the participant's fictitious address is canceled as a matter of course. To prevent cancellation based on the expiration of time, the participant can demonstrate to the satisfaction of the Secretary that the participant remains in imminent danger of becoming a victim of DV. And this is, of course, something that my ex would have exploited could she have done so. She could have just said, hey, I'm still in danger, please help me. And they would have, of course, done it, because they don't exercise any discretion at all. They just kind of take your word for it. Issuance of this fictitious address to my ex was proper. And this is where they go into the lack of discretion that the Secretary of State has. So I'm arguing that the temporary restraining order was not sufficient to support that the issuance of the fictitious address in light of the statutory scheme set forth above is appropriate. The Supreme Court concludes, contrary to my assertions, that the Secretary of State was required to issue the fictitious address by law. And the reason why makes sense. They're going to go into that. We're going to go ahead and jump down to the legislative history. This is why. So the legislative history reveals that the Nevada legislature specifically declined to allow the Secretary of State to inquire into the circumstances. They're basically saying that they don't want the Secretary of State to use its thinking power, its brain. They want the Secretary of State to just trust the applicant. And they specifically mention here that earlier versions of the bill required the Secretary of State to make a determination. These versions of the bill required the Secretary of State to actually think things through before they give these addresses out and to determine whether or not somebody's an actual victim. But throughout the process, the legislature ultimately modified the bill, and they decided to remove the potential decision-making function from the Secretary's role. This is where that subsection 4 came into play. They decided that instead of giving the Secretary of State the power to make a determination and conduct fact-finding, they were going to tell the Secretary of State what to do by giving the Secretary of State a list of what they call evidence. And if the Secretary of State is given one of those pieces of evidence, then the Secretary is not allowed to turn on its brain. It is required to say, okay, thank you for providing this. Here's your address. This is not a process that involves discretion or the exercise of discretion or any kind of thought. This is a process where the Secretary of State is following instructions. They're operating as a drone. They're operating on pre-programmed instructions. Those pre-programmed instructions were put into subsection 4, and that is basically the Secretary of State doing what it was told to do by our legislature. There is a learning opportunity here for any of you who are watching. And that learning opportunity is for you whenever you have one of these issues come up and you're going to the Supreme Court for clarification on law, for you to actually look into these debates. You could go online usually and download the legislative history of a bill. You can download the minutes. You can download the debate between the legislators, and you can use those on appeal. You can use these specific things to sort of guide your appeal, just like the Supreme Court of Nevada is doing here. In my case, you can do that in researching your case. Anyway, in the present matter, my ex completed the application for entry into the program. Consistent with subsection 4, she provided the temporary restraining order. Regardless of my arguments concerning the standards for obtaining a temporary restraining order, because the law specifically provides that a temporary restraining order constitutes sufficient evidence to support an application, my arguments in this regard fail. This is where I learned the power of the law. This is where my videos, Fairness versus the Law, The Machine, and Statutes, Rules, and Case Law come from. Those 3 videos came from my realization of going through this case. I realized at this point in time, the judges do not really concern themselves with general overarching principles of fairness, right and wrong, morality, and logic. Judges interpret existing law, period. That's what they do. That's why I strongly recommend my viewers watch those videos all the time. Statutes, Rules, and Case Law will control the outcome of your case. Watch the video, Statutes, Rules, and Case Law. Watch the video, Fairness versus the Law. Watch the video, The Machine, because what you're going through is not an emotional sort of let me help you, I feel bad for you process. What you're going through is a gigantic machine, and you have to figure out how to turn the wheels, how to pull the levers, how to push the buttons to get the outcome that you need to protect your child. And this is where I realize that this is how the courts operate. And that's not necessarily such a bad thing, because these debates on policy shouldn't really occur in the courtroom in the first place. Policy debates should occur in the legislature. And in fact, I explain why in the video, Policy versus the Law. Please watch that video. I explain why it is important that these powers are separated between these 2 different governmental bodies. The judiciary interprets and applies existing law. The legislature debates these principles of fairness and morality and ethics and fashions the law that the judiciary is then bound to follow. I explain why this is so important in this country and probably in every country in the video, policy versus the law. Please watch that video. Okay, so now that I have lost on this point, you'll see where my backup plan succeeds. So the Supreme Court of Nevada concedes that the Secretary of State was required to accept my exit into the program, and that my arguments on the interpretation of that law fail. However, my backup argument and my focus on the fictitious address program's interference with my ability as a parent to be involved in the joint custody of my child is interfered with, and they're now going to examine whether the interplay between that program and my custodial parenting rights is a constitutional issue. And before I even get into the Constitution, by the way, guys, I have a video on the Constitution. I really want to make clear to my viewers that we are really lucky to have a Constitution in this country, because if you didn't have a Constitution, the law would control completely the outcome of this case, and it would not matter that I lost the ability to take part in the upbringing of my son, in knowing where he lives. I really need people to understand that the law, as it is drafted, controls your life one way or the other. It will control every aspect of your life. Many times you don't even notice how it does this, but it does this. And without a constitution in place, we are at the mercy of a sometimes incompetent or sometimes short-sighted legislature. In this particular situation, the legislature has put forth laws that clash with our ability as parents to be involved in our child's upbringing. And luckily, we have a constitution here that shackles or chains down or restricts the legislature's ability to infringe on some of our fundamental rights. So we are going into that now. The Supreme Court states here that the balancing of the protection of DV victims with parental rights is going to be discussed. Parents who share joint legal custody of their child have a legal responsibility for their child and for, quote, making major decisions regarding that child, including those related to the child's health, education, and religious upbringing, unquote. The Nevada courts have recognized that parents have a liberty interest in the care, custody, and management of their children, and that is a fundamental but not absolute liberty interest. To make these decisions requires that both parents are informed regarding the child's circumstances and experiences. Knowing where the child resides allows a parent to have the input regarding the environment in which the child is being raised. Going into the next paragraph. When a parent shares joint custody of his or her child and enters into a fictitious address program, the custodial parenting issues become intertwined with DV victims' needs to protect themselves. Thus, in such a case, the rights of a custodial parent to know where their child resides has to be balanced against the important state interest in protecting victims of DV served by the state's fictitious address program. Seeking disclosure of a co-parent's confidential address, the Nevada legislature recognized that such conflicting interests may arise in certain cases, as one of the fictitious address statutes specifically permits a court to order the Secretary of State to disclose a participant's address to a specific party. I want to tell you guys, frankly, that even though the law says a judge can do this, no judge was going to do this. They're just not going to do it. They're too scared. No judge in Nevada is going to say, oh, well, under subsection 2B, I think that this is not appropriate. You should tell them where your child... No. They're going to say, let's play it safe. I'm not going to let you find out where your child lives, because if I do and then you kill them, now I'm going to lose my election, or I'm going to get kicked off the bench, or I'm going to get all this media, they're just not going to do it. Without the Supreme Court of Nevada forcing them to do it, which is what they're doing with this case, I don't buy for a second that the district judges would have applied the statute correctly. The Supreme Court of Nevada is essentially, with this opinion, twisting the arms of all the lower court judges and forcing them to do what they were supposed to do in the first place with this publication. Let's go ahead and proceed. The statute does not delineate the procedure by which a court can do so. So the Supreme Court of Nevada takes the opportunity to address the issue right now. The Supreme Court of Nevada is stating that they're going to determine what procedure a court should apply in resolving a request to disclose a program participant's confidential home address, because the legislature failed to set forth any procedure at all. They set forth a subsection that allows a judge to consider it, but they didn't actually explain how a judge can consider it. A majority of cases, or a majority of states have enacted confidential address statutes, but only one court has addressed a situation similar to the one presented here, and that is a case in New Jersey. And the Supreme Court of Nevada, by the way, 2 more learning opportunities for you guys. If you took notice earlier, the Supreme Court of Nevada conducted a 50-state survey to find out how other states dealt with this problem. They looked into the case law in all 50 states, and they couldn't find anything except in one state, which was in New Jersey. And so then the Supreme Court of Nevada is going to go ahead and take a look at New Jersey's approach, and if they find it to be adequate, they're going to adopt it either completely or partially, so that we in Nevada can follow either completely or partially that particular New Jersey procedure. Okay, so here they're going into the actual court proceedings in that New Jersey decision, Sacro, and they're talking about how they stipulated to joint legal custody, and they left it to the district court to determine whether she would have to disclose her true residential address as requested by her then husband. The district court ordered her to disclose the true address to him, and she sought review of the determination requiring disclosure of her true address. On review, the New Jersey court held that courts in general were not bound by the fictitious address program, but concluded that she may nonetheless have a right to keep her address a secret. And in order to balance the competing interests in her having a confidential address and knowing where the child was living, the Supreme Court in New Jersey concluded that the determination has to be made as to whether disclosure is in the child's best interest. So they're basically tying disclosure into the best interest factors. The court directed that on remand, because she was seeking to curtail her husband's parental rights, she would have the burden of demonstrating that confidentiality was in the child's best interest. Again, she has to prove it in a court of law, unlike the approach that my ex is taking, which is, hey, here's an application from me, give me my confidential address, thank you, bye. And I'm not even involved in the process. She's basically infringed on my right as a parent to know where she lives without even me being involved to controvert any of her allegations. And that's where we're about to get to with Nevada. So the Nevada Supreme Court finds the reasoning of the New Jersey court persuasive because it requires that any decision to compel disclosure of a program's participant true address, they have to basically take into account both the interest of a DV victim in remaining hidden for the person who harmed them and the interest of a custodial parent's right to make decisions regarding his or her child. And so they're going to adopt this framework into Nevada courts, considering a request for disclosure of confidential address and adapting it to be consistent with Nevada law. So I want to mention one more thing to you guys. We talked earlier about persuasive authority and mandatory authority. Well, this New Jersey case at the time was persuasive authority, and the Nevada Supreme Court did what it sometimes does, and it took that case and embedded it into Nevada law. So now, in a way, it becomes mandatory authority, though it's not really in the sense that you can't use the Sacro decision as mandatory authority, but you can use the Falconi v. Secretary of State decision as mandatory authority, and it, for the most part, is an adaptation of that other case. But this is how sometimes decisions from other states can become controlling in your state, either completely or in part. Petition for writ of Mandamus. The Sacro Court addressed the matter before in the context of an appeal from an order entered in the divorce action. Had the issue arisen in the context of our custody action, I could have possibly filed a motion in my case to get the lower court to compel disclosure of my ex's home address. But here, my ex did not do that. She waited until after the custody order was entered. So by doing that, the court doesn't have jurisdiction in our actual case, in our child custody case, to make this determination anymore. That might be something that my ex's attorney exploited as well. By waiting until after the custody order was entered, she effectively deprived that judge of having any control over this issue. So the Supreme Court of Nevada is going to create a new way, a new mechanism for me and other parents to get relief when a judge is not able to exercise this particular discretion in that case because that particular parent waited until after the final judgment was entered or until after the decree of divorce was entered to get their confidential address or their fictitious address. So what they're going to do is allow parents to challenge this using the writ of mandamus in lower courts, which is what I'm going to do later on in the series. To do so, I have to show a couple of things, I think, here. I have to show, let's see here. Okay, so apparently I have to file the petition for writ of mandamus in the lower court, and I have to include both the Secretary of State as a respondent and my ex as a real party in interest. They're also stating that they want, I believe they want this to be done in a specific district. Maybe they mentioned that at some other point. because I think they want it to be filed in the district of the court that has control over the child custody issues, but I don't see that in here now. Burden to establish disclosure. When filing a petition for writ of mandamus to compel disclosure, it is my burden to establish that writ relief is warranted. A custodial parent generally has a right to know where his or her child resides, even when the child is in the other parent's physical custody. By demonstrating that I have joint legal custody, I have met the initial burden of proving that I have a right to know where my ex resides. Guys, take a second glance at that. They're not even saying that I need physical custody. They're saying joint legal custody is enough. And in this case, I have joint physical custody also. So it's even more obnoxious that my ex has been able to perpetuate this for so long. I have joint legal custody and joint physical custody, and she still is keeping our child secret from me. So this is one of the really big eye-opening things, I think, for the Supreme Court of Nevada. One of the big things that concerns them is that a parent with physical custody of a child has no clue where that child lives when in the other parent's custody. It unnerves them. And there's some footnotes where they mention this. If you go down and take a look at the footnotes, you'll see what I'm talking about. If I am seeking disclosure and I meet that burden, then the analysis discussed will come into play. One of the things that I love about this decision is it takes away the discretion of the lower court to consider the petition for writ of mandamus. Usually, a lower court has discretion to consider a petition for writ of mandamus, but the Falconi v. Secretary of State mandates that the lower court consider the petition. This is one of those very, very rare situations where you can file a petition for writ of mandamus in the lower court and that judge is forced to consider it. And that's because of the Supreme Court of Nevada publishing Falconi v. Secretary of State. They have done a tremendous service by publishing this decision, because now judges in the lower courts can no longer sidestep this issue. They have to preside over these petitions and they have to make a determination on these issues, thanks to Falconi v. Secretary of State. So once I have shown that I have legal custody of my son, the burden shifts from me to my ex to now show that she is an actual victim. If she does not show that she is an actual victim, she instantly loses. And they are citing here the clear and convincing evidence standard. They're tying that into this. So she can't even just use word versus word. She has to show by clear and convincing evidence that I have committed DV. So all of the full force of the law now is coming up against her. All of the things that she was able to sidestep and avoid before by exploiting that loophole, by exploiting the legislature's failure to set forth a procedure, that's all coming home now. And she's going to have to figure out how to deal with that. Spoiler alert, she doesn't even show up. She doesn't even go to court. Most likely her attorney told her, you're screwed. Don't even go. You have no evidence. Just skip it. And so when I file the petition and the hearing comes, she doesn't even go to court. And so she's going to fail to satisfy this burden. And once she fails to do so, her fictitious address will be canceled. So going forward, I think there's another section here. Yeah. So if theoretically, because this is not something that my ex actually succeeds in doing, if theoretically she had shown up in court and she had shown by clear and convincing evidence that she was an actual victim, then at that point in time, it wouldn't necessarily be case closed. The burden would shift back to me, and I would be given an opportunity to show that despite being an actual perpetrator, it's still in the best interest of the child for me to know where that child lives. I could imagine some situations where this comes up and is actually a valid point. Like say we have a situation where we have a victim, but maybe she's a meth addict or she has a history of alcoholism or something like that. And so the court might say something like, yeah, it's true that you were a victim of DV, but we still think that this other parent should know where you live because you have a whole bunch of other issues that are really concerning. And so it's not good. I mean, they're still going to protect that parent in other ways, but they may say, we still want that perpetrator to know where you live because of all these other issues that you have. Again, that's all theoretical stuff, guys. It didn't come up in my case because she didn't even get to that point. She failed to show that she was an actual victim. Under this approach, the court is addressing, under this approach, the court has to consider the facts. The court has to make factual determinations. And for this reason, they conclude that the district court rather than the Supreme Court is the appropriate tribunal for seeking this relief. And this is why my petition was denied, because the procedure that they have created for me and for other parents requires fact-finding. And so they cannot conduct that fact-finding that is necessary for them to conduct because they're an appellate court. And so they're forced to deny my petition at this point in time. But again, guys, I'm just able to take this decision and go back to the lower court and get everything taken care of. And that's the end of it. And here are all of the footnotes. You guys can take a look at these footnotes. There's more than just this one footnote. There's several other footnotes. But this footnote here specifically clarifies to the lower court judges, hey, our denial of Alex's petition does not impair his right to seek relief in the district court under the procedure outlined in this opinion. They're making it crystal clear that you can't use this denial against Alex. This denial is only because of the fact-finding limitations on the Supreme Court. And they're specific, and I use this, guys. I use this when I file it in the lower court. I let the court know, don't just deny this, please. Don't just read the label and not even open up anything and read it. There's a footnote here from Justice Cherry in footnote 4 that says that I have the right to come back and force you guys to apply this procedure. Going into the aftermath, I didn't file any documents, so I incurred $0 in costs. My ex's attorney didn't file any documents, so she incurred $0 in costs. Let's see, didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably not spent any time at all reading this. I don't know. She might have read it, but it wouldn't necessarily have been just for my ex. It might have been for her to sort of, adapt that new, piece of case law into her mind for, all of her clients going forward. So I don't think I'm going to put any time on my ex's attorney for this. When my ex's attorney really is going to have to consider this case is when I actually file the petition for writ of mandamus again in the lower court. So I think at that point in time, it would be more appropriate for me to go into my ex's attorney fees when it comes to reviewing and conducting her research of this case. So all of that being said, I think it's reasonable to put the attorney fees of my ex's attorney at $0. The Secretary of State, that's a little different. So the Secretary of State, of course, didn't have any costs because they didn't file anything. And so that's going to be $0 in costs for them. But their attorney fees, I think they would have at least needed to review this decision and contact the confidential address program to let them know this is a major, major change to how the confidential address program works going forward. So I think that it's not entirely unreasonable to put that at least 1 hour for the government to not only review this decision, but to communicate with the confidential address program and update them on the changes to Nevada law going forward. So 1 hour at the rate of $250 an hour is going to set the government's attorney fees at $250. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.